Hello and welcome to Team 2's course project final. Our company of choice is Alphabet Inc., the parent company of Google Inc. Team 2 is comprised of Juet Payne, David Pritchett, Paul Tissinger, and Arthur Syed. Let's begin. Throughout human history, there's always been a drive to advance the human race to the next level. Whether it be the discovery and harnessing of fire or the invention of the internet, humans have evolved from elementary to more sophisticated with each step. Prior to the internet, connections were made through face-to-face interactions, telephone calls, and yes, even old-school pen and paper letters mailed through the USPS. Learning something new meant going to the library and reading periodicals, books, newspapers, and more. Once the internet came of age, all of that changed. We all now need information immediately. No more waiting for the library to open. We need the library right now. The primary way to discover something new is to go online and use a search engine. The leader of search engines is Google. Google was started in 1998 in Menlo Park, California. The company that Group 2 has followed on this journey through the legal arena for this course is Google's parent company, Alphabet Inc. Alphabet Inc. was founded in 2015 as part of a restructuring effort by Google Inc. Alphabet Inc. is a collection of businesses with Google as head of the class. Part of the reason to restructure was to allow Google to narrow its focus on mission of making bets that have the potential to change the lives of people. Other companies that fill the Alphabet Inc. bucket include, but are not limited to, Access, Calico, Capital G, GV, Nest, Verily, Waymo, and X. These other bets companies, as labeled in the company's annual 10-K filing with the SEC, represent the arms of Alphabet that reach beyond the internet-based companies and products like Google, Google Maps, YouTube, Google Play, Gmail, Google Docs, and Chrome, to name a few. Alphabet's mission with these other bets is to utilize technology to try and solve big problems across many industries. According to the founder's letter that was part of the Google's initial public offering in 2004, Google is not a conventional company. We do not intend to become one. Because of the internet-based nature of Google, this makes sense. Alphabet goes on to say, you could expect us to make smaller bets in areas that might seem very speculative or even strange when compared to our current businesses. Google seems to be determined to remain on the cutting edge of technology, whether internet-based or otherwise. Throughout our journey here, we will take you through cases that span several topics of law and involve companies and individuals from diverse backgrounds. There is a case involving the Attorney General of the state of Mississippi regarding whether Google polices the results of its search engine, a case involving an attorney who felt wronged by the search results for his own name, and a case involving a failed tech company trying to regain its former trademark that Google had obtained. There was also a case involving Waymo, a spun-off company formerly known as Google Car. That case involved not only a former employee of Waymo, but also Waymo's competition, Uber. In a case involving consumer protection, the parties involved were individuals that were using a seemingly more private application of Google Photos. We wrapped up our analysis of Alphabet Inc. by looking at another type of case, arbitration. This arbitration involved another company that had a very similar name to Google, seemingly by design. Throughout this presentation, we will share these cases and hope you find it informative. Our first case covers constitutional, international, and administrative law, Google Inc. versus Hood III. Google operates YouTube, a popular internet platform where videos can be uploaded, shared, and viewed. Google earns revenue through services called AdWorks, which places third-party advertisements alongside search results and YouTube videos. Google AdWorks has implemented policies to prohibit advertisements for counterfeit goods, dangerous products or services like drugs and weapons, products designed to promote dishonest behavior such as hacking, hate promotion, or otherwise offensive or inappropriate. In May 2013, Hood informed Google via a litigation hold that Mississippi was investigating and evaluating Google's conduct related to a search algorithm, autocomplete function, advertising policies, and other related functions. This investigation was done with the purpose of determining whether there existed any violations of Mississippi law. Hood warned that there could be civil or criminal litigation. Hood called on his colleagues to issue an administrative subpoena to force Google to admit what they had done and make changes to block some of the search results that come out on top of legitimate sites. Google claimed that federal law immunized Google from liability for the complaint of conduct. In November 2013, Hood sent another letter to Google making several demands regarding content and search results and rejected the notion that Google was immune from legal action, stating that Google had been investigated for its own actions, not merely a publisher of third-party content. On December 19, 2014, Google filed this lawsuit alleging that Hood's investigation was against Google's immunity under the Communications Decency Act. On December 19, 2014, Google also moved for a temporary restraining order and a preliminary injunction. Hood filed an opposition and a motion to dismiss. In the case of Google Incorporated versus Hood III, under the law with the aforementioned facts, the resulting decision was for the district court to grant preliminary injunction, leading to them eventually vacating the injunction. For Hood, this meant that he was restricted from enforcing his subpoena and from bringing any further criminal action against Google Inc. for giving their user third-party information. The court's decision was based on some key factors. First, when Hood's office requested Google to remove certain videos, Google obliged. Not only were the videos removed, but they created a trusted flag system to review such videos and take them off the web. Secondly, in return, Google filed a lawsuit against Hood stating that Hood's investigation violates Google's immunity under the Communications Decency Act. It can be concluded that Google's internet services are constitutionally covered by free speech. Hence, we side with the reversal decision of the Fifth Circuit Court that upheld Google's claim as well as their rightful protection of immunity under Section 230 of the CDA. Our second case covers negligence, product liability, and warranty. Mark G. Maughan versus Google Inc. The plaintiff appellant Maughan claimed that a search for Mark Maughan Accountancy results in a list of websites that suggested that Mr. Maughan had accepted a contingent fee for preparing tax returns. Maughan stated that this amounts to a scarlet letter in the accounting world. On November 22, 2004, Mark G. Maughan and Brown and Maughan filed a class action suit against Google Inc., seeking damages and injunctive release for libel, product liability, and unfair business practices. On or about January 18, 2005, Google filed an anti-SLAPP motion to strike the complaint and for the attorney fees and costs under the anti-SLAPP statute. On February 24, 2005, the trial court granted the motion to strike the complaint, but was silent on the attorney fees and costs. On March 18, 2005, Google filed a separate motion for the attorney fees and costs under the anti-SLAPP statute. In the case of Maughan versus Google Technology Inc., under the law with the aforementioned facts, the resulting decision of the Court of Appeal, 2nd Division. In the case of Maughan versus Google Technology Inc., under the law with the aforementioned facts, the resulting decision of the Court of Appeals, 2nd District Division 1, California, was to grant Google Inc. an anti-SLAPP motion. They were awarded $23,000 in attorney fees and costs. Based on the Code of Civil Procedure Section 425.16C1, the statute states a prevailing defendant on an anti-SLAPP motion shall be entitled to recover his or her attorney fees and costs. The granting by the appeals court of the anti-SLAPP motion to Google Technology Inc., along with payments to Maughan for association attorney fees and costs in the amount of $23,000, sends a clear message regarding half-baked litigations to recover damages and injunctive release from findings on search engines. Our next case covers contracts and property law. Eric Speck versus Google Inc. In 1998, Eric Speck designed a suite of e-commerce software and formed Android Data Corporation, ADC, to license the software to clients. In 2000, Speck applied to register the trademark Android Data with the United States Patent Office. During the time that Speck was dealing with downsizing his business, another technology startup calling itself Android Incorporated was developing what would come to be known as the Android operating system. In 2005, Google purchased Android Incorporated. And in November 2007, Google released the beta version of its Android software to the public. On June 4, 2009, Speck, ADC, and ADI filed a lawsuit against Google, the founders of Android Inc., and the Open Handset Alliance over the use of the Android mark. The lawsuits raised 2 claims under the Lanham Act, one for trademark infringement and one for unfair competition. Speck also advanced a claim for violation of Illinois Deception Fair Trade Act and 2 claims for common law trademark violations. On June 22, 2009, Google and the other defendants filed a motion to dismiss the claim based on the premise that Speck had abandoned the Android Data trademark and asked the court to cancel the plaintiff's mark. In the case of Speck versus Google Inc., under the law with the aforementioned facts, the resulting decision of the circuit court was to reject Speck's claim against Google. Google Inc. was allowed to continue with the Android brand, and Speck's Android mark was counted as abandoned. Similar case in the future will review infringement laws from the perspective of when the trademark was abandoned and how long it was not in use. The Seventh Court counted Speck's trademark as abandoned, stating that a trademark is abandoned if its use in commerce has been discontinued with no intent to resume use. Furthermore, in accordance with the Lanham Act, if there is non-use for 3 consecutive years, that is evidence of abandonment. Secondly, Google began using Android in commerce in November 2007. Speck tried to revive its Android mark in December 2007. This was rejected as well, since this was a month after Google released a beta version of the Android software. The lesson learned from this case is that a trademark is only as good as the ongoing business application, or rather, activeness of the intended purpose for issuance. Team 2 agrees with the decision of the district court that basically states that if a trademark is issued, the company should either use it or lose it. The next case we would like to discuss involves employment and discrimination law, Waymo LLC versus Uber Technologies Inc. In both 2009 and 2012, Waymo had employment agreements with then-employee Anthony Lewandowski. Both agreements had similar language regarding the requirements by both parties to enter into binding arbitration in the event that Lewandowski had any complaints related to the listed issues in the agreement. Also, the arbitration would apply any claims by Waymo against Lewandowski. In February 2013, Waymo filed suit in the Northern District Court of California against Uber Technologies, claiming violation of the California Uniform Trade Secret Act, the Federal Defend Trade Secret Act, the California Business and Professional Code, and the Patent Statute. In the Northern District Court of California, Waymo alleged that during his employment at Waymo LLC, Mr. Lewandowski misappropriated Waymo's information by downloading 14,000 documents for the benefit of Uber Technologies. The Northern District Court of California asked Waymo if it would forego any claims in any form against Lewandowski regarding arbitration requirements of the employment agreements. Waymo agreed with the condition that Uber does not open the door with respect to those agreements by referencing the agreements in court or relying on them in any proceedings. The United States Court of Appeals Federal Circuit ruled in favor of the plaintiff, Waymo LLC, in which they reached a settlement of $245 million with Uber Technologies Inc. The settlement is for 0.34% of Uber's equity, which is but a fraction of the $1.9 billion settlement that Waymo initially wanted. It is believed that Lewandowski stole trade secrets from Waymo and that it was shared with Uber to enhance their autonomous technology. Over 14,000 trade secrets were downloaded before he began his work at Uber. It is unknown if the proprietary information was used by Uber, but because these files were shared with them, the companies decided to reach a settlement. This prevented a long, drawn-out case and allowed for both companies to continue their self-driving programs. As concluded by the California Court of Appeals Federal Circuit, Lewandowski's arbitration clause in his Waymo-Lewandowski employment agreement does not compel arbitration of the case pending litigation. Unlike the civil case, the federal case involved possible criminal violation of federal trade secret laws. Thus, the arbitration clause in the Lewandowski's employment agreement does not apply to or absolve him from criminal investigation. Waymo and Uber were able to reach a settlement because of this. Team 2 agrees with the legal findings of the case and the California Court of Appeals decision. Next, we will discuss antitrust and consumer protection law, Rivera versus Google Inc. Between around March 2015 and March 2016, Linda Beth Rivera was photographed by a Google Photo user, and the photos were uploaded to a cloud-based Google Photo service. The photos were scanned immediately upon upload. This created a template of Rivera's face by mapping and recording the distinct facial measurements based on the unique contours of the facial structure. Joseph Weiss took photos of himself that were automatically uploaded to Google Photos, scanned by Google software, and used to create a face template similar to the one created from photos of Rivera. According to the complaint filed by Rivera and Weiss, the face templates were then used by Google to find and group other photos of them and recognize their gender, age, race, and location. Neither Rivera nor Weiss had knowingly given consent. The plaintiffs Linda Beth Rivera and Joseph Weiss filed a lawsuit on behalf of all affected Illinois consumers in the Illinois Northern District Court Eastern Division against Alphabet's Google Inc., claiming that the search engine's photo sharing and storage service violated their privacy and Illinois state law by collecting and storing biometric data from state residents' photographs using facial recognition software within the Google Photo service without their permission. The defendant, Google Inc., filed a motion for summary judgment in the Illinois Northern District Court, Eastern Division, arguing that the plaintiffs were not entitled to money or injunctive relief because they had not suffered any harm. The Illinois Northern District Court granted Google's motion for summary judgment, to which they stated that the court lacked subject matter jurisdiction because the plaintiffs had not suffered concrete injuries. United States District Court ND Illinois Eastern Division determined that the collection of such biometric information did not cause any injury in fact. The claim was counted as insufficient and did not hold any grounds in court. As shown in the Illinois Northern District Court's decision in favor of Google Inc., unless plaintiffs can show concrete injury from a violation of the Illinois Biometric Information Privacy Act, their chances of a win in the State Court of Illinois are slim to none. The district court's decision implies that without cause of industry to plaintiffs, Google would continue to successfully challenge the jurisdiction of Illinois state courts. However, Team 2 believes that if Alphabet's Google Inc. does not take aggressive measures to protect consumers' information from disclosure, they will most likely risk losing consumers' confidence and business. Lastly, we will discuss business associations, securities, and ADR. This case is an arbitration. Google Inc. versus Goggle.com Inc. Since 1997, Google Inc. used the Google mark for its search engine and other internet services using the domain Google.com. Google Inc. has numerous trademark registrations for its Google mark that it owns with governmental trademark authorities worldwide. Google Inc. previously entered into a uniform domain name dispute resolution policy proceeding against the original registrant of Google.com, Google.net, and Google.org. The complainant, Google Inc., electronically submitted a complaint and payment to the National Arbitration Forum requesting the transfer of domain names from respondent to complainant. Google Inc. versus Goggle.com Inc. Under the law, with the aforementioned facts, the judicial panel declines jurisdiction over the complaint over the respondent's related claim of reverse domain name hijacking. The case is thus dismissed. Google and the other parties enter into a settlement agreement. The domain names were later transferred to a third party with whom Google had not had prior dealings. Due to this, the agreement was not set forth in the complaint. Rather than side with either party, the three-person National Arbitration Forum panel punted the decision declining jurisdiction. By doing so, the panel members are suggesting that the courts are better suited to handle such business disputes. Team 2 believes that Google Inc. will most likely pursue the complaint in court with a reasonable probability of success. One observation regarding these cases was that most of the cases started with Google Inc. as the defendant. However, after filing an appeal, Google became the plaintiff. Because Google is a search engine, most of the cases revolved around how information was entered, presented, or utilized by others in their attempts to make Google responsible for regulatory violations of the search engine by others. In all appeal cases, the appeal court's decision favored Google. Google's social and ethical responsibility and exposure to litigations from violations thereof are usually limited due to the way a search engine operates, how it is utilized by the public and businesses, and how their indirect e-commerce affiliation is protected by federal and state law. Regarding applicable laws, our observations reveal that most common element between the suits filed against Google was their false pretense or perception of Google's social or ethical responsibility for guarding or protecting the information of businesses and consumers against other users of the search engine. However, similarly to the First Amendment's protection of freedom of speech for citizens, the same protection also extends to businesses such as Google. Throughout this project, Group 2 has analyzed 6 different cases for Alphabet Inc. that involved many different parties from different backgrounds and with varying complaints. While the cases involved different areas of law, there was a common theme presented in the analysis. self-preservation. In the Week 2 analysis, Google Inc. versus Hood, we saw Google defending its own First Amendment rights. The following Week 3 analysis saw the case of Mahan versus Google Inc., in which again, through the anti-SLAPP motion, Google was able to defend its First Amendment rights. Week 4 brought on intellectual property case Spec versus Google. In this analysis, we saw that Google will take what measures it needs to protect its interest in acquired intellectual property. The case in Week 5, Waymo versus Uber Technologies Inc., involved one of Alphabet Inc.'s other companies, Waymo. Once again, though, Alphabet Inc. was litigating to preserve its business. The case dealt with trade secrets being shared with the competition. BIPA, or the Biometric Information Privacy Act of Illinois, was the main focus of the Week 6 case, Rivera versus Google Inc. Google had to defend itself against violating that act by showing that prior consent was given for Google to use the biometric information in Google photo uploads. The final case we analyzed was a case in arbitration. Google Inc. versus Goggle Inc. Incorporated again demonstrated the tenacity of Google in self-preservation. Goggle.com was using an all too similar domain name to lure users to their website for potentially fraudulent gain. From the legal perspective, Google is not afraid to stand up and protect its rights, reputation, and property from harm. Although, nowhere in these cases did we see a desire to settle the case outside the courtroom. Even when the issues caused personal perceived injury to the lawyer, Mahan, or to the two plaintiffs in Illinois whose faces were uploaded in their templates. From an ethical perspective, it is clear that self-preservation may supersede the ethical treatment of the issues. All in all, Alphabet Inc. and Google Inc. are tenacious and outstanding companies. Thank you for watching.